Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're going to be discussing the I-212 consent to reapply for admission to the United States. Sometimes it's called an I-212 waiver. An I-212 is somewhat similar to an I-601 waiver in that one has oftentimes previously, in both cases, in both the context of an I-601 and an I-212, one has been previously found inadmissible to the United States in some context. Now, in an I-212, it's slightly different. I'll get into that in a minute. It should also be noted that an I-212 may occur in conjunction with an I-601 waiver, and I'll get to that further in a moment. To quote directly from the INA directly, and I'm taking this from the USCIS website, uscis.gov, under Section 212A9A of the Act, an alien who was deported, excluded, or removed under any provision of law is inadmissible if the alien seeks admission to the United States during the period specified in Section 212A9A of the Act, unless the alien obtains consent to reapply for admission during this period. Let me give you an example of what we're talking about under Section 212. Basically, those who have been subject to what's called expedited removal or expedited deportation from the United States are probably going to go ahead and need an I-212 in the 5 years following their removal, pursuant to a prior amendment to the overall immigration apparatus, or the overall code under which immigration law operates. There was the creation of so-called expedited removal. It was essentially like deportation proceedings that just happen at the border, if you will, when someone's trying to enter. The result of being removed under such proceedings is that the individual is ineligible to return to the United States for at least 5 years after the removal. There are different circumstances that may dictate certain time periods under which one may be found inadmissible, but the rule of thumb that I go by is 5 years in an I-212 context. That being said, in an expedited removal proceeding, I see this happen rather frequently in an expedited removal context. An individual may be found to have committed fraud and misrepresentation during an interview with an immigration officer. And if a finding such as that has occurred, that's a legal ground of inadmissibility on top of the I-212. So you're going to have to deal with an I-601 waiver for fraud and misrepresentation. There's another video on this channel that discusses I-601 waivers and fraud and misrepresentation specifically. But the thing to take away is in that situation, an I-212 might need to be undertaken in conjunction with a 601. So you've got two different kinds of sort of waiver-like remedy operating at the same time. Again, you're mostly going to be dealing with I-212s in the context of a prior deportation, expedited removal. In some cases, immigration officers, especially U.S. Customs and Border Protection, usually due to timing constraints and resource constraints, they may ask an individual if they want to voluntarily depart the United States. And if they're allowed to voluntarily depart, I-212 may not apply. But with respect to expedited removal, you're going to have to deal with I-212, and I-212 can operate. You may have to deal with an I-212 in conjunction with an I-601.